Very well, we are coming to you live from Milimani Law Courts, and today we are here at Milimani Law Courts. This is a live court update, and right here, as you can see, lawyer Angela Mulwa was rearrested yesterday, and she has been arraigned in court today for the murder probe of Dr. Mutiso. And as you can see the live pictures here, she's engaging with her lawyers, lawyer Dansan Omari, and as you can see also, lawyer Shadrack Kwambu is also here, Stanley Kinyanjui, Martina Swiga, they are all here. These are live pictures coming to you live from Milimani Law Courts, and we will continue to bring you live updates from the court as the proceedings unfold. Welcome all our viewers. This is Court Helicopter Live Update. We are coming to you live from Milimani Law Court. And right now, the lawyers are already here. We are waiting for the prosecution counsel and the judges, the magistrate to arrive. As you can see, these are live pictures live from Milimani Law Courts. A good afternoon to all of you watching Court Helicopter News Live. As you can see, we are live from Milimani Law Courts, and today we are following the latest development in the development of the ongoing investigation linked to the murder of Dr. Victoria Mutiso. And today, lawyer Angela Mulwa was arrested yesterday evening by the DCI homicide detectives, just hours after she had secured her release on 1 million cash bail. And we are here live from the Milimani Law Courts. As you can see on the screens, this is Court Helicopter News Live. Angela Mulwa is an advocate and the daughter of Frostbite Mulwa. She and another person, Nelson Masiga, had been held for 14 days over the alleged recovery of a Range Rover linked to a disputed property in Mlolongo. On Wednesday, the Mavoko court declined a further detention request and granted them 1 million each cash bail. Shortly after she processed the release, DCI homicide officers rearrested her. And as you can see, she's here. She has been arraigned today. The DCI are seeking 14 more days to detain her for the murder of Dr. Victoria Mutiso. What we know so far, the murder of Dr. Victoria Mutiso, a clinical psychologist, took place in the late July in Upper Hill, Nairobi. Several members of the Mulwa family have been persons of the interest or held in connection with the related probes involving a long-running land dispute in Mlolongo, a recovery of high-end vehicles, and the broader homicide investigation. Angela Mulwa has been representing family members in some of the earlier proceedings, and the courts have been balancing the investigations and also all the allegations that have been on this matter. And as you can see, the lawyers are already here. Lawyer Dansan Omari, Lawyer Stanley Kinyanjui, Lawyer Shadrack Wambui, Lawyer Martina Swiga. They are all here, and as the defense team, they are here ready to defend their client, Lawyer Angela Mulwa. And we are currently waiting for the magistrate to come and the prosecutors to come. And everyone is here. People are expecting. We are waiting to see what will happen today, what will unfold today in court. And as you can see, these are live pictures from Milimani Law Court. Members of the public and the media are also following the developments closely. And as you can see, and this remains an active criminal investigation and a court process. We will not speculate on guilt or innocence, but we want to presume that everyone is innocent until proven guilty in the court of law. So to our beloved viewers, those who are watching us, we are so much humbled to have you on board as you follow these proceedings closely. If you have any verified updates or questions, please drop them in the comments. We'll address them as you stay here for the facts and as you stay here for all the unfoldings today live from Milimani Locus. Remember to comment, remember to share, remember to subscribe. This is Court Helicopter News for all live updates. We will be bringing you today the live update of the unfoldings here at Milimani Law Courts Live. Stay tuned and thank you so much for joining us. Those who have already joined us, we appreciate so much. This is Court Helicopter News live from Milimani Law Courts.
Every sentence is ending. It's so painful. It's so painful. When we talk conversation, I'm really blessed. The person is the other one for the country and the
Miscellaneous application 3846 of 2026. Angela Mulwa.
Good afternoon.
Good afternoon.
Amurage,
Yes.
appearing alongside Miss Mutheo
Yes.
for the state.
All right.
Morning, good afternoon, Your Honor.
Good afternoon, Counsel.
My name is Dan Selimari. We shall be appearing together with Martina Swiga.
I'm present.
Together with
Martina Swiga.
I'm present.
Swiga.
Yes, Swiga. Good afternoon, Your Honor.
Good afternoon.
Mr. Timothy Kilonzo.
Yes.
Present.
Good afternoon.
Ms. Margeto Melody.
I'm present, Your Honor.
All right.
Mr. Jeff Kamneve.
Yes. All right.
And Mr. Stanley Kinyanjui.
Present, Your Honor. Good afternoon.
Good afternoon.
Your Honor, Mr. Cliff Ombeta is online. I don't know if we are virtual or...
No, we unfortunately, we would normally have a formal request for the virtual platform.
Very well.
Yes.
Then he can be placed because he's a substantive holder of his brief.
All right.
I'm holding his brief, Mr. Cliff Ombeta.
All right.
Very well. Your Honor, there is
Yes.
a preliminary issue
Yes.
that we wanted to address before the miscellaneous application that is intended to be presented before you is prosecuted, if the court allows us.
All right.
Thank you. Your Honor, the respondent in the dock is an advocate of the High Court of Kenya with over 25 years of practice. She was arrested and presented before the Mavoko chief Magistrates Court in a miscellaneous application E494 of 2026.
In miscellaneous number?
Miscellaneous criminal application number E494
Yes.
of 2026, where the state was seeking for 21 days to investigate the murder of one Dr. Victoria. The court had the counsels for the respondent, where I was one of them and all this team. The court, in its wisdom, gave a ruling dated, there's a ruling dated, the first ruling is dated the 4th day of August 2026. This is a ruling by your sister, L. Kwamboka. Sorry, on the first one, the first ruling is dated 19th day of August.
All right.
There are confusions around this. The first ruling, Your Honor, I got it right. It is on 4th day of August 2026 by your sister, SRM L. Kwamboka. In this ruling, the court granted the state 14 days to detain her. At the expiry of the 14th date, the state came back to seek for a further extension of 7 more days. We fought that application and we put the investigating officer on the dock to justify the 14 days, the 7 more days. The investigating officer confirmed to the court that the investigations are complete. The file has been taken to the office of the ODPP. And with that, the court declined to grant the 7 days over the investigation of the death of Dr. Victoria. The respondent here was admitted to a bond of 1 million shillings. Each respondent shall execute a bond of Kenya shillings 1 million with 1 surety of a similar amount. Other conditions were set in place. The court will have a look at those conditions. One of the conditions is in order number 6, where the ODPP is at liberty to exercise its constitutional mandate under Article 157 of the Constitution. You're aggrieved with the bond terms. We made an application for review instantly. On the following terms, the respondent's mother is in custody pursuant to the investigations of the late Dr. Victoria. Her brother, who is an advocate also, is in custody. There was nobody to execute the bond terms. The court reviewed those terms, Your Honor, and it delivered its decision on 20th day of August 2026, yesterday. And the court gave the following orders. She executes a bond of 1 million shillings with one surety. In the alternative, she deposits a cash bail of 1 million shillings and 2 contact persons.
Let me get that term again. Just what you just said.
She was
yes.
admitted to the same bond terms of 1 million
Yes.
with sureties, and this time with an alternative of cash bail of 1 million shillings
Okay.
and 2 contact persons. That was yesterday. She deposited the 1 million cash bill, and she was released. Immediately, she was arrested. She has been brought before you. So now, let me put now the application, having given that the court can be given those, the court can have a look at them. Your Honor, the first question before you, do you have jurisdiction to entertain a matter of the same person, of the same subject matter, the investigation of the murder of Dr. Victoria, where your sister has released the respondent on 1 million cash. Is this court sitting as an appellate court? Only the High Court can sit over this issue. You know, that is the critical question we are raising. That this was not disclosed to you. This application before you is purely to embarrass you and embarrass the judiciary. This is, in essence, what is called abuse of the state powers. And the abuse of the state powers is not disclosed to the judiciary. And that is why we are objecting to the admission of this miscellaneous application. You know, let me give this explanation properly in the case that the state has been given and the court has been given. This is the Constitutional and Human Rights reference number 165 of 2011. Justice Ngugi J. Venn, before she went to the Court of Appeal.
Sorry?
It is Constitutional reference number 165 of 2011. Justice Ngugi Judge then. This is Rosemary Wanja Mwagiru, Stephen Mbogwa Mwagiru, and Robert Gidhui versus the Attorney General, Tatu City, and others.
Okay.
The judge captures in paragraph 33, because it will be a long citation if the court can be given the copy.
Yes.
Okay.
I have a copy.
I can read first.
Yes.
The court will capture that.
Right.
You know, this is what the judge is saying. The office of the DPP is an independent office, and the court will, in ordinary circumstances, be reluctant to restrain the exercise of its powers. That notwithstanding, the process of the court must not be misused or otherwise used as an avenue to settle personal scores. The criminal process should not be used to harass or oppress any person through the institution of criminal proceedings against him or her. Should the court be satisfied that the criminal proceedings being challenged before it have been instituted for the purpose other than the genuine enforcement of law and order, then the court ought to step in and stop such maneuvers in their tracks and prevent the process of the court being used to unfairly wield state power over one party to a dispute. The judge says, in this respect, I will adopt the words of the court in the case of investment and mortgage. It is there. What are the words in paragraph 27? A quotation. I agree with the respondents that it is within their mandate to investigate crimes where there is reasonable basis of commission of offense, and that in performance of their duties, they are independent institutions. The office of the DPP, established under Article 157, is an independent office which is empowered to conduct its duties free from any influence or control by the authority. Inactions must be within the law and in accordance with what the Constitution dictates. One such dictate is that in the exercise of their powers, it is to have regard to the public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process. You know, this is now what we are telling you, that this is an abuse of the legal process. In paragraph 34, still the ODPP is being blasted by the late Justice Majanja. He says the office of the DPP and the National Police Service are independent, and this court will not ordinarily interfere in the running of their offices and exercise of their discretion within the limits provided. The judge is still condemned. Paragraph 37, they move further. Paragraph 38 provides an explanation. You know, here it is. An abuse of the court process would in general arise where the court is being used to improper purposes as a means of vexation and oppression, or for ulterior purposes, that is to say, court process is being misused. Paragraph 39 gives that. Paragraph, Your Honor, 41, when you retire, you'll check about it. Paragraph 42, you'll check about it. The most interesting part for the world to listen is paragraph 52. The judge talks of a galloping litigant. A galloping litigant is a litigant moving scenes of the same forensic battle from one jurisdiction to another, engulfing nearly all institutions and means of dispute resolution, either simultaneously or successfully, with little or no merit, and putting a pinch of criminality on or otherwise civil disputes must be stopped. And if a subordinate court entertains him, the High Court must check it. Experience has shown some litigants who will dress up their disputes in so many garments and present them to every authority available within our national borders, and even personalities with no legal powers here to assist in the resolution of the same dispute. They vex their opponents and everyone else. They may be reminded to vilify, intimidate, and black. The authorities are there. My team of associates should deal with it. You know, what is before you? Is a serious abuse of the judicial process. It is the ODPP in Mavoko who approved the miscellaneous application. It is the DCI who came to court and took the dog against that advocate. They are the same officers paid by us who now want to vex, to harass that respondent. Thank God Article 50 came in. The police could have detained her for 10 years. But we said no under the new constitution. They must be brought to court within 24 hours. We know very well, Your Honor, it is not these friends of mine who are police officers here. There are powers above them. That have sworn life and death, this girl, her mother and her father, and her mother and her brother will never see freedom. The first miscellaneous application was before your brother, Honorable Nsarifu. We argued it. The second one was before Honorable Kwamboka. We argued. Today we are before you. After we dispense with this one, Monday they will be in Kibera or elsewhere. You know, this is what we are seeking, that these miscellaneous cannot be admitted. And we will crave for that ruling. In the judiciary account, 1 million shillings of that advocate is there. She is released on the investigation about the death of Dr. Victoria. The police arrest, they ignore the cash bail, they bring that to you. You know, before the radical surgery of the judiciary, it was normal during the Chunga time. It was normal for people to be dragged to court. They plead not guilty, the courts enter guilty, and they are sentenced. When the radical surgery came, those issues were brought up. You know, remember that time, interviews by JSC were not existing. Because once somebody has been appointed a judicial officer, that's fine. Today, we are on performance-based approaches and merit-based interviews. This state want your file to be put a black mark. Had this thing been brought to you and you looked at that, you could have raised your pen and said, I put it down. so that they either take her to DCI headquarters and detain her there, or detain her away from the judiciary. Your Honor, in summary, my final remarks is that this PO must succeed because the law provides for protection. This is a word of the court. This is an office of the court. This is a vulnerable suspect before you. If they have evidence to charge her for murder, nobody can stop the DPP from charging her. But they cannot be producing every day miscellaneous application over the same issue. Let me allow the voice of Our Lady to come to soften the proceedings.
Good afternoon, Your Honor, once more.
Good afternoon, Counsel.
I wish to fully associate with the submissions of lead counsel, Mr. Danstan Omari, and wish to point out in particular
We said the name was
Miss Martina Swiga.
Right.
To point out in particular the grounds in which we rely on for raising this preliminary objection on a point of jurisdiction. Your Honor, you have been told, and you may have already confirmed from the documents that we have supplied to the court, that the suspect that is arraigned before you was under custodial orders, as was delivered at Mavoko on the 19th of August 2026. Order number 7 confirms the custodial orders previously issued by this court, having served their purpose, are hereby vacated.
You said was delivered in court on which date?
On the 19th of August 2026. When the respondent was released on terms, number 7 confirms that the custodial orders previously issued by this court, having served their purpose, are hereby vacated. You have also been informed by Mr. Omari that the IO at Mavoko, under oath, confirmed, and it is on the record, that investigations were complete. And when investigations are complete, it is well known that the miscellaneous file is closed. Then the DPP prefers the appropriate charges on the suspect, who then becomes an accused person. We have supplied an affidavit by the IO1 Gilbert Okello, dated the 3rd of August 2026.
Can
I
you
wish
repeat
to
the name?
Gilbert Okello.
Right.
Sergeant Gilbert Okello swore an affidavit dated the 3rd day of August 2026, where he confirms in the final paragraph, allow me to read, that the resultant police files will be presented to the office of the ODPP to allow appropriate direction on the charges to be preferred against the respondents, which can only be possible if this honorable court grants us applicants 21 days to complete investigations and have the respondents plead to the appropriate charges on the 21st day of August 2026 before a court of competent jurisdiction. Your Honor, it is the 21st day of August 2026. Instead of the IO, together with the DPP, to approve appropriate charges, they are now forum shopping before you after being denied the extension of the 21 days they so desperately sought to complete investigations. It is under oath, Your Honor. They indicated that the respondent that is before you is to take plea on appropriate charges on the 21st day of August. Yet here we are, fighting yet another miscellaneous application on a Friday afternoon. Your Honor, you're being invited by the applicant to sit in the capacity of revising the orders that were granted in Mavoko, where they were denied 21 more days for purposes of completing investigations. They are inviting you to sit as an appeal from a sister court of similar jurisdiction because they were denied 21 days at Mavoko to hold the respondent for further investigation. We urge this court not to fall into the invitation by the applicants who are blatantly abusing the court process by this vexatious application. You know, I also wish to point out to you this application that is dated the 21st of August 2026. The miscellaneous application as opposed to charges. Signed by one CPL Romana Odwor. In paragraph 14 of the notice of motion, the grounds that they rely on, Your Honor, I wish to bring your attention to that specific paragraph.
Paragraph 14.
Paragraph 14 of the application that is before you today.
Yes. Yes, proceed, counsel.
And it reads that continued custody is sought. Continued custody is sought. So they confirm without any iota of doubt that there was custody indeed, and they are seeking continued custody. And it reads that the continued custody is sought because there are compelling reasons to believe that the release of the respondent at this stage may lead to interference with witnesses known to the respondent, interference with pending investigation, and collusion with persons at large, some of whom are senior police officers. Your Honor, if you look at my submissions and the particular areas I have highlighted to the court, you will notice that, number one, not only are they contradicting themselves, in one point they are confirming that investigations are complete. They are confirming that they are seeking you to give them continued custody, to hold the respondent that is before you continuously, as they have the laxity, without any prejudice occasioned to them, to hold the respondent. After we got sight of this affidavit on the 3rd of August 2026 by one Gilbert Okello, we were fully prepared to come to any court of law to argue for bail on the 21st day of August 2026. Because this affidavit was made under oath. Unless the deponent of this affidavit is now denying, or going against his own words. As I rest and yield the floor to the rest of the defense team, Your Honor. We pray that this application not be admitted on the preliminary basis. There is no jurisdiction that this court holds. Knowing very well jurisdiction is everything, and you cannot act if there is no jurisdiction. You must down your tools, Your Honor. They are seeking an extension of what was happening in Mavoko. One more point I forgot to bring out. In that same application that is before you today, paragraph 17. Paragraph 17 reads, having regard to the technical nature of the outstanding inquiries, the applicant is seeking 14 days to complete the investigations, which investigations in Mavoko they indicated had already been completed. And the court indicated under paragraph 7 of its directions that the custodial orders had already served their purpose. It is my final submission that this court does not grant any invitation to hold the respondents for continuous, unending, perpetual custodial investigations. The respondent before you is a sweetheart of this court. And like everyone in this courtroom, she is the only one likely to be prejudiced by any order that this court issues. Therefore, Your Honor, as I rest, I thank you for your time, and we pray that the submissions that we will submit will be considered in accordance to the provisions of the law and the submissions that we've set out for. Thank you, Your Honor.
Right. Good afternoon.
Mr. Kilonzo,
Yes.
I shall be submitting and aligning myself with the sentiments of my seniors. And mine will be to preempt what the state might rebut. The state shall stand up and tell you that this application before you today is a different application than that of Mavoko.
Your Honor, maybe you can get direction. I do not know why counsel is submitting on a presumption of what our reply would be. I would very humbly pray that the court directs that they present their objection without purporting to speak for the state.
I think, counsel, you will be well guided. Make your submission. The court will
I am
hear
well
you.
guided.
Yes, just proceed.
Therefore, the application that is before you similarly looks a little bit different from the one at Mavoko. But however, I will put it before this court that it is not so, bearing in mind that the application at Mavoko on the supporting affidavit, paragraph 4 to 8, the application reads,
You referred to which paragraphs?
from paragraph 4 to 8 of the supporting affidavit of
Okay.
the application of Mavoko.
Of the application from Mavoko.
Yeah, the one in Mavoko.
Do I have that application?
It is before you.
That is B494.
Yes, sir.
All right. You're referring to the supporting
The
affidavit?
supporting affidavit, paragraph 4.
All right.
The grounds they have listed for continued detention under paragraph 4 reads, under the circumstances which is actively under investigation by our homicide team based at the DCI headquarters Nairobi, who have so far arraigned 2 suspects before Milimani law courts to face charges of murder. And the application that is before you today, the officer swearing the affidavit states he is of the Homicide Investigations Bureau at the Directorate of Criminal Investigations headquarters. The officer at Mavoko made the application on that front, taking in mind that he's seeking a continued detention for investigations relating to the investigation being done by the Homicide Investigations Bureau. Therefore, it is a similar application raised on a similar issue. Secondly, I will rely on the authority of the High Court at Nairobi, JWK versus IKE, E056 of 2023,
Repeat the citation again.
JWK versus IKE, High Court at Nairobi, Civil Appeal number E056 of 2023 by Justice Nyaonda. The court
Is it before me? Is it here in what has been supplied? You said it's a civil appeal.
Yeah, it's the Civil Appeal.
Yes, proceed.
On paragraph 9, it defines what an abuse of court process is. Justice Nyaudi proceeds to state that situation may arise given rise to an abuse of court process are indeed many. It involves situations where a process of court has not been resorted to fairly, properly, honestly, to the detriment of the other party. And it continues to list various other situations, such as 9A, B, and H, where B reads instituting different actions between the same parties simultaneously in different courts, even though on different grounds. Paragraph H, where 2 actions are commenced, the second asking for a relief which may have been obtained in the first. The 2 applications do satisfy the listed grounds, which include an abuse of court process. The preliminary objection we have raised, as per the reputable case of Mukisa Biscuits, is a pure point of law which is determined on the face of the pleadings. And we are asking this court, as it retires, to look at the face of the pleadings, because we have not brought out on the merits of the application, but we have brought out on purely the face of the pleadings that the said officers swore on oath. Similarly, the said officer who arrested the suspect herein was shown the cash bail. The cash bail the accused person, the suspect, was issued at Mavoko. the cash bill is before you. And in his knowledge, did not consider that cash bill. It shows a quite disregard of the rule of law, disregard of the court orders of Mavoko, and the test for every pre-charge detention application, as was determined by Honorable Justice Ngugi Joel, the double test is that an officer, the state, must persuade the court that it is acting in absolute good faith. On the face of the application that will be before you, the officer has not made mention of the Mavoko case because it is trying to hoodwink this court, misrepresent facts, misrepresent the law, and invite this court in engaging in its own abuse. Probably it is trying to put to test the judicial officer before it. And as the scripture says, do not test the Lord your God. Yes, that's my Your Honor.
Good afternoon, Your Honor.
Good afternoon.
I fully associate with my senior counsel's submissions. Your Honor, this is a classic textbook example of forum shopping. It's an attempt to override an existing bail court order of a court.
Just a second. Just give me a second. Sorry about that.
That's okay.
All right, Counsel, you may proceed, and please remind me your name.
Miss Mageto.
Miss Mageto.
Yes.
All right.
Your Honor, as I was saying, this is an attempt to override a subsisting court order.
All right.
Given by a court of concurrent jurisdiction. And instead of the applicant herein complying with the order or appealing to the higher court, they rushed to this court to reset the custody clock, Your Honor. Your Honor, the applicant is inviting you to detain the suspect without justification. Your Honor, if you have a chance to go through the ruling of your system.
Counsel, I'm taking notes. I would ask that you take the speed of your colleagues.
It's okay, it's okay.
Yeah, so that I get to record whatever you say. All right. Okay. So proceed now.
You know, when you retire, when you're perusing through the ruling of your sister, dated 20th August 2026, the court stated that it had declined the prosecutor's application for a further 7 days after finding that the investigation had been completed and that the continued detention of the applicants was no longer justified. Your Honor, we are inviting this court to dismiss this application as it is an invitation to infringe upon the rights of the suspect. I will be relying on criminal petition number 47 of 2019. Rashid Mohammed Echesa versus DPP.
Rashid Mohammed Echesa.
Yes. Versus the DPP, DCI, the Inspector General of Police, and the AG in paragraph 21 The court said, even though the DPP enjoys such wide powers of prosecution under Article 157, that does not mean that the powers are unfettered or absolute. It is the duty of the court to ensure that the DPP acts within the law without infringing on the fundamental rights of citizens. When the DPP abuses those powers, the court has cardinal duty to intervene. Further, I would also rely on the case of Rosemary Wanja Magiru.
Rosemary?
Wanja Magiru versus the AG, where the court stated that should the court be satisfied that the criminal proceedings being challenged before it have been instituted for a purpose other than the genuine enforcement of law and order, then the court ought to step in and stop such maneuvers in their tracks and prevent the process of the court being used to unfairly yield state power over one party to a dispute.
Counsel, you're reading from, I'm looking at what you've supplied.
Paragraph 22.
Paragraph
Of the
22.
criminal petition number 47 of 2019.
This is 47 of 2019?
Yes, in paragraph 22.
Yes. This is, sorry, this one is not highlighted like the rest, but you're looking at, all right, I see. The office of the DPP. Okay, I see. All right. Proceed.
Yes, you know we pray that this court dismiss the application and ensure the rights of the suspect are not in any way infringed.
All right.
I am Jeff Kanyepe,
Yes.
similarly counsel for the accused. Perhaps Your Honor, if the record can reflect, I'm also holding brief for Mr. Shadrach Wambui.
Shadrach who?
Shadrach Wambui. I'm holding brief for Mr. Shadrach Wambui as well.
The last name?
Wambui.
Wambui. Okay.
Yes.
Proceed.
Your Honor, like the rest of the team, I'll align myself with the submissions that have been made, also by Senior Mr. Mari. Save that I will need to reiterate that even taking note of the application that precipitated the ruling by your sister at Mavoko, I'm also grounds in support of the notice of motion. Ground number 9. Your Honor, it was abundantly clear.
Of which motion? This motion before me or the
No,
other motion?
The motion that had been filed in Mavoko that resulted in the rulings.
Okay.
The same is dated 3rd August 2026. Your Honor, looking at ground 9 of the notice of motion that I've just mentioned, it is abundantly clear that the investigators are pursuing a charge of murder. It is explicitly mentioned that flowing from that investigation, there's a probability that the suspect, or rather the respondent that is before you, might be charged for the offense of murder. As such, it will be duplicitous, as my senior has put it, to entertain what I understand to be a third application, a third custodial application over the same facts. Your Honor, similarly, I'm of the position that investigations ought to be concluded where after arrest is made and a suspect is charged before a court of law. For that, I'll be placing reliance on the pronouncements by the judge in the case of Michael Rotich versus the Republic. That was Justice Kimaro.
The case again?
The case of Michael Rotich versus the Republic, 2016 EKLR, where the judge, Michael Rotich.
Do I have it here?
No, I regret. I am here to furnish the court with the same.
You see,
I am here to
the
furnish.
number?
2016 EKLR.
Okay.
It is Justice Kimaru who, in that ruling, was decrying the state for the habit of arresting and then seeking more time to investigate people. And in closing, the judge noted that it is unlawful for the police to seek to have a person who has been arrested. It is unlawful for the police to seek to have a person who has been arrested to continue to remain in custody without a formal charge being laid in court. Your Honor, the police in this matter, or rather the state in this matter, has had over 3 weeks to conduct the necessary investigations, and yet they seek 3 more weeks to detain the respondent.
I seek for 3 or 2.
My apologies, I believe 2 more weeks. They seek 2 more weeks to continue detaining the respondent for the purposes of investigations. And like I've submitted, my Lord Justice Kimaru indicated that that is improper. Secondly and lastly, on the element of investigations, nothing precludes the investigators from continuing with the investigations well after plea has been taken in this matter. The Supreme Court was very clear in the case of Khalid and 16 others versus the Attorney General.
Just hold on, pencil. Your citation?
The citation is Khalid and 16 others versus the Attorney General and 2 others. 2019 KESC 93 KLR. Similarly, I'm here to furnish court with a copy of the same, but at paragraph 92, the Supreme Court affirmed that in a criminal process, investigators, or rather the investigation process is always continuous. That nothing prevents investigators from receiving new evidence, even after the accused has been charged in the course of trial. And it is the duty of the prosecutor to bring the new information and evidence to the attention of the court. As such, it cannot be argued before you, Your Honor, as a justification that they need 2 more weeks to continue with investigations. In the circumstances, Your Honor, I will reiterate the plea, as my seniors have done, to resist the invitation to consider the custodial orders application grounded under section 36A, and subsequently order that the respondent be set at liberty. Your Honor, that will be all for me.
All right.
That's the end for the respondent's defense team. The prosecutor can respond, or they can consider and say, let have this matter.
All right. Prosecution.
Yes, Your Honor, we are opposed to the objection that has been raised by the defense. Your Honor, we will be briefed in our response. And from what has been submitted, we want to respond. We have only condensed the issues into 3 main issues. That is the issue of jurisdiction. That this matter is sub judice. Abuse of state powers or forum shopping. Yona, on the issue of jurisdiction, Yona, we
Counsel,
very
you stated 3 main issues.
yes, Yona,
So
that
you have jurisdiction.
sub judice,
Okay. All right.
abuse of state powers.
All right. All right. Proceed.
Yes. Yona, we very humbly submit that this court has jurisdiction to entertain the miscellaneous application number 3856/2026. And Your Honor, submit that, as has been alluded by the defense, the state does not come to this court as an appellate court. Your Honor, we wish to point out that miscellaneous E3856/2026 and E494/2026 are distinct in nature, and in particular, the miscellaneous number E494/2026, Your Honor, E494/2026 before
Yes.
Mavoko Law Courts, Your Honor, is on investigations on the offense of forgery, forgery of title, theft of motor vehicle, and malicious damage to property. Your Honor, while the miscellaneous application before you Your Honor, and also fraudulent eviction, sorry. Your Honor, while the application before you,
The last one was fraudulent.
fraudulent eviction.
Okay.
While the application before you today touches on investigations
This is number E.
number 38, E3856, on the touches on investigations into the murder of one Dr. Victoria Mutiso. Your Honor, it is a very humble submission that those are two distinct offenses and investigations. Your Honor, the matters are equally being investigated by different investigating officers. Miscellaneous number E4, the miscellaneous matter at Mavoko, Your Honor, was which has been
This is
senior
E-
sorry,
E490. Yes.
Senior Sergeant Gilbert Okello. Your Honor, this is Gilbert Okello. This is a DCI officer based at Athi River East. From Athi River East DCI rather. Your Honor, the application before you is an investigation by one. Is an investigation emanating from the homicide division of the DCI headquarters, and whose the affidavit therein, Your Honor,
invite the court to find that these are the applications. Before Mavoko Local Tiona also has one Nelson Masiga Makaralu. Indeed,
Say the Mavoko application has 2 respondents.
the Mavoko, yes. Your Honor, if indeed was
Nelson Masiga. Or
Masiga Makaralu.
All right.
Makaralu, yes. Yes, Your Honor, if indeed the state was coming to this court as an appellate court, as has been alluded, Your Honor, the second respondent would equally be part of these proceedings, and which he is not. Your Honor, the principle of sub judice states that, rather, is where the same facts are proceeding before another, a different court. Your Honor, as we have highlighted, it is clear that the facts, the circumstances, and the parties are different.
You say that the facts.
The facts,
Yes.
the circumstances,
Yes.
the offenses under investigation, as well as the parties, Your Honor, are different.
All right.
So for that reason, we pray that the court finds that this matter is not sub judice, and the same is properly before you, and we should be allowed to proceed with the application. The issue of abuse of state powers, it is a very humble submission, Your Honor, that the application is properly before you under Section 36. That 36A of the CPC. Your Honor, read together with Article 49, 1FG of the Constitution. Your Honor, the purpose of the application before you the reason for which she has been produced in court. Your Honor, we wish to submit that is the purpose for which we are before you today. Our application is clear. That the respondent has been brought before you to allow the investigators, Your Honor, time to investigate the murder of one Dr. Victoria Nthunya Mutiso, where the respondent
said.
The respondent in this matter before you was arrested on the 20th of August 2026. Your Honor, that is yesterday. Your Honor, that could not possibly have been sufficient time to allow the investigators to complete the investigations into a complex murder or offense such as this. So, Your Honor, it would be misleading to this court to indicate that we are to seek for continued detention. Your Honor, we have Your Honor, we submit that she was arrested yesterday to seek for continued detention. Your Honor, the fact that the respondent has other active investigations, Your Honor, do not invalidate the present investigation. And Your Honor, if they are fit to grant her bail bond, Your Honor, that can only go to show that she's equally enjoying her rights to a fair trial, and which, as a state, we have no issue or objection to. But Your Honor, pray that we be allowed the days as sought to allow investigations into this, into the matter before you. Very briefly, Your Honor, going into the circumstances under which this offense was committed, we wish to further submit
The circumstances in which?
the offense under investigation was committed. We urge the court, Your Honor, to take time and appreciate that this has been an evolving offense that has unfortunately led or ended with the loss of a life.
This has been an
evolving offense, Your Honor, that has unfortunately ended with the loss of a life. Your Honor, the same involved organization at various levels.
Yeah, I object to that line of facts about arguing what they have deponed here. We are purely on the question of law. The facts, if they want to argue, if it is admitted, then they can argue about how the circumstances of the death occurred. Let us restrict ourselves to the issue that we have raised, is about whether this court has jurisdiction, and that's all.
Your Honor, I think it would be unfair for the defense to object to our touching the facts, yet in their submissions they also touched on the facts. Your Honor, I was actually building up to, if my learned senior had allowed me just 1 minute, would have. We are not necessarily going into the facts of the matter, Your Honor. We
confine your submissions, counsel. Don't get too far into the matter.
Very
Let's
well.
address, I think, since it's the question of jurisdiction and whether this court is seized with jurisdiction, let's hear the submissions on that.
Very well.
Yeah.
Very well. You are well guided.
Thank you.
Your Honor, we shall be urging the court to to appreciate the facts of this matter. And Your Honor, allow the prosecution, the investigators, Your Honor, the 14 days as sought, Ndiona you know what you wanted to bring out is that the complexity of the investigations, and in particular, Your Honor, you wanted to highlight the fact that one of the suspects in this matter is a senior police officer.
We are still objecting to that line of argument.
Very well, Your Honor,
It's purely courts to courts. Is Mavoko and Milimani allowed to handle two matters? That is all. Who has killed who has escaped, those are geared to arouse emotions that this matter needs to be, so that we are kindly let state deal with the issue of jurisdiction. Only. That's all that we ask.
Counsel.
Very well, Your Honor, we are well guided.
All right.
So, Your Honor, we pray that the court allows our application and finds that the court has jurisdiction. I shall cede the floor, Your Honor, to Ms. Muteo to add on for the state.
All right.
You know, just to add a few issues. Just as my fellow counsel, Mr. Murage has said, the issues in Mavoko are malicious damage, forgery of title, and theft of motor vehicle, and just to add an eviction.
Malicious damage, forgery of title,
theft of motor vehicle. And that is evident on the ruling that the defense has supplied us from Mavoko, that is the ruling for 494 of 2026. Paragraph 2, it has clearly indicated the issues in question, the issues that the matter in Mavoko are what I have just stated. Your Honor, the issues in this court are issues of murder, and that's where we are in this court, and they are totally different. Totally different to the ones in Mavoko, Your Honor. And looking at the said applications are also different, and different departments. And that's why, Your Honor.
Just a second. You said they're from different departments. You said
They are from, sorry, Your Honor, they are from different departments, Your Honor. Therefore, the application by counsels does not suffice. Because even looking at the said applications, the facts, the issue argued in the said applications are not the same. Your Honor, to note, the powers of this court, Your Honor, are conferred by the Constitution and various statutes. And you can see, as per the Magistrate Act, this court is properly seized of the matter and has the requisite jurisdiction to entertain the proceedings and grant the sought orders by the prosecution. Your Honor, and the merit appeal raised by counsels has no merit and ought to be dismissed because of the factual matrix are totally different, Your Honor. You know that's all.
Battle.
Yes, Your Honor, Ms. Martina. The state is trying to convince you that our PO has no merit. And that the application that exists in Mavoko and the application that is before you is different. Allow me to read the application in Mavoko, the affidavit sworn on the 3rd of August 2026, paragraph 7 and 8. And it reads,
Just a second, Counsel. You are now referring to...
I'm now referring to what is before the Mavoko court.
That is E494.
578 of 2026.
Is it 578 or...
Paragraph 5, no, paragraph 5, 7 and 8.
Oh, okay.
Yes.
All right, proceed.
Paragraph 5 reads, in relation to the murder case, the two respondents need to be subjected to the process of forensic digital identification in terms of the review of CCTV cameras, their communication networks in relation to the suspects who are held for murder charges. Paragraph 7, that because of the foregoing, the respondents, other than facing the offenses of theft of a motor vehicle, for other offenses related to interfere with the leads and information being exploited by the officers for the property and the murder case. Those two applications, the one that is before you and before Mavoko Court, are very similar. The state is trying to convince you that there is a difference in terms of the facts and the circumstances. We have laid the basis, Your Honor. With reference to the fact that the parties are different, we wish to bring to the attention of the Honorable Court that the second respondent in the Mavoko Court, although he was granted bail, he is still in custody. That is the only reason that that suspect is not before you. Only because the suspect that is before you, being an advocate, was able to get the bail, and shortly after paying for bail and enjoying her rights, she was then rearrested by the state.
Proceed.
There is no distinction between the custodial orders that are being sought before you and the custodial orders that were sought, granted, and thereafter vacated in Mavoko. We are not saying there is an abuse of state powers. We are saying there is an abuse of court process.
Just hang on, Counsel. All right. Proceed.
And just because the application that has been filed may be proper does not negate it from the fact that it is vexatious and vexing all of us. And for the record, the suspect was already admitted on bail. Any compelling reasons they would want to convince you of failed to satisfy the threshold as is indicated by the law. So they cannot rely on a ground saying there is probable interference of witnesses when a court of similar jurisdiction in Mavoko is saying admit the suspect to bail. In any account, the suspect before you is not an investigator. She has no capacity to investigate. How is she going to interfere with purported investigations? There is absolutely no justification for her not to enjoy the right to bail that she was given. My good friend, the prosecutor, has indicated that this is not an attempt of continued investigation, but I will point out to the affidavit under paragraph 18, I believe. Yes, under paragraph 18, where it reads
The current
that
application.
yes.
Okay.
They have tried to convince you that they're not seeking continued custody, but it is being laid bare in plain English that continued custody is sought by the state. They have also not convinced you how it is this court has jurisdiction. Therefore, Your Honor, as I yield the floor to my senior, Mr. Danstan Omari, I will bring to the attention of the court the ruling that is dated the 19th of August, delivered in Mavoko, which states under paragraph 12, although those concerns are insufficient to justify continued custodial detention in the circumstances where investigations are complete, they can appropriately be addressed through stringent and proportionate bond conditions, which the court then granted to the respondent that is before you. I also wish the court to pay attention to paragraph 9, 10, and 11 of the same ruling, which informs the court of how it is the court arrived at granting the respondent bail, guided by various provisions of the law. And therefore, as I rest, Your Honor, may you find merit in our preliminary objection on the grounds of jurisdiction and sub judice, and do not let the investigators and the state to enjoy a second bite of a cherry they have already digested. That is all, Your Honor, and I wish to thank you for your time.
All right.
Your Honor, the final remarks. I request the court to have a ruling by the Mavoko court dated 19th day of 2026, and the state can have a copy.
You say it's dated?
It is dated 19th day of August 2026.
I don't know why Malala Tina wants to give us the ruling after.
I gave it. I had already given it
to the state.
Now the state was served with this, and we argued, and the court was given copies.
19.
You are not given.
You have it. They have it.
We have not. You know, we have been given, but it's okay.
No. They have it. Let us. They are my good buddies. You know, I'm reading only paragraph 1. Allowed for everybody to understand. The magistrate, the judicial officer says the respondents Angela Mulwa, that one, and Nelson Masiga were previously presented before this court in an application by the prosecution seeking custodial orders to facilitate investigations in connection to the murder of Dr. Victoria Mutiso. That's all. That is a judicial officer's ruling. After the affidavits were put, people were cross-examined, the judicial officer distilled what we all argued and said the custodial was for the investigation into the murder of Dr. Victoria Mutiso. That can only change by this being challenged in the High Court. Nobody can give an interpretation to this ruling. And that's your honor why we are saying in 2 words, the question about investigation of murder of Dr. Mutiso has been concluded by the Magoko court. Lastly, that being the position, the court has no jurisdiction. And the state cannot amend this ruling. Neither can I amend this ruling. I can't vary it unless a high court does that. And kindly pronounce yourself on that so that we can proceed with the next phase. Thank you very much. That is the end from our side.
All right. The court will take a brief break, and the court. I'm sorry, counsel. My voice is a bit affected.
Yes.
But I'm stating that the court will take a brief break, and then we will be able to return with the ruling.
Much obliged.
All right.
We appreciate it. Thank you very much for that.
Or let me put it, directions, depending on what.
Much obliged, Your Honor.
Thank you.
Thank you.
Ambitious.